Senator from the 48th, you wish to continue? You wish to continue? We're going to have some questions. Chair recognizes Senator from the 42nd on questioning regarding the bill or the resolution H.R. 4.
Senator Yield.
Yes, sir.
Isn't it true that Georgia has spent many, many years trying to get Tennessee to respond to the obvious mistake that occurred?
There have been a number of resolutions adopted by this General Assembly pointing out the errors in the boundary line, and there have frankly been at least one resolution passed by the General Assembly of the state of Tennessee acknowledging that the line is in error.
And isn't it true that among other resolutions, there was a resolution signed by Governor Carter that Tennessee ignored?
I know that there was a resolution signed during the Carter administration, resolution adopted and signed during the Carter administration, and obviously this dispute remains unresolved.
And isn't it true that this amendment would finally direct the state of Georgia, if Tennessee doesn't accept this reasonable offer, that the state of Georgia would enforce its rights in court? Isn't that correct?
That's absolutely correct.
Thank you.
Chair recognizes Senator from 29th for a question.
Will the senator yield?
Certainly.
Senator, could you tell us the river that there's been a lot of discussion about with respect to this resolution is named the Tennessee River. Are you aware of the historical background or context of that?
The Tennessee is an Indian word. The state of Tennessee is actually named after the Tennessee River. Tennessee River is not named after Tennessee. Tennessee is the etymology of the word Tennessee is an Indian word of indeterminate knowledge, but most scholars believe that it's correctly translated as Big Spoon, which suggests to me that the Indians who named that river knew, even though they couldn't foresee the European immigration to this continent, they knew that that river, with this bountiful flow of water, would be a big spoon for many, many states and peoples. Yeah, thank you.
No further questions, Senator. Chair recognizes Senator from the 54th to speak to the bill.
Thank you, Mr. President, members of the Senate. I rise in support of House Resolution 4, not because I think that it rightfully marks the boundary between Georgia and Tennessee, but because I think that it is a fair offer made in good faith that will finally resolve a long-standing dispute and will result in the least disruption in the lives of people involved. Senators, I beg your indulgence. I do not believe that in the 3 years I have been in this body, I have ever addressed an audience other than you. I address my arguments to you and I address my conversation to you, but on this one occasion, I ask that you would allow me to also address those that report and cover this particular story. And I beg your indulgence that I might pull back the curtain on that ancient rhetorical trick that, while probably not invented by politicians, has perhaps been mastered by them. And that is the act of laughing or ignoring questions that you don't want to answer or for which you don't have an answer. This is what my neighbors in Tennessee are doing today. When we discuss the boundary between our state and theirs, they laugh, they ignore, they crack jokes, they send bottled water with Davy Crockett and a coonskin cap. But they have yet to articulate a single legal claim for any property south of the 35th parallel, ever. The only time that they have asserted a claim was in the context of joint action between the state of Tennessee and the state of Georgia, which required concurrent agreement and resolution, agreement which our state has never given. What else? Surely not acquiescence. We have consistently, since our yielding of claim in 1802, prior to the existence of the state of Tennessee, claimed the northern boundary of the main channel of the Tennessee River, where said river crosses the 35th parallel. You can't get adverse possession against a government, so our neighbors surely do not assert that as their legal right or claim. So I humbly ask my friends in the press, ask one more question. When they shrug, when they laugh, ask one more question. Ask them, by what legal right does the state of Tennessee claim land south of the 35th parallel? The grant from Europe that precedes this nation gave Georgia the 35th parallel. The state of Georgia, which precedes this nation, claimed the 35th parallel. When the state resumed the Union, depending on how you look at that argument, after the Civil War, we claimed the 35th parallel. Well, I'm in the Georgia General Assembly, and maybe you don't want to take my word for it. So what have other learned minds, other scholars who have studied this issue found? Well, you can look to the Federal Energy Regulatory Commission, who in 1981, in a decision rendered by that body, found that the boundary between Tennessee and Georgia, or Georgia and Tennessee, is still in dispute. Maybe you don't want an administrative body and you'd rather it come from the courts. The United States Court of Appeals for the D.C. Circuit in 1974, the boundary between Georgia and Tennessee is still in dispute. Well, maybe you think, those are not Tennesseans and they've got their own claims to the land. So maybe you would ask me, what has Tennessee said before their late jocularity on the issue? 1889, by act of the General Assembly of Tennessee, whereas there are grave doubts as to the location of the state line between Georgia and Tennessee, and it continues. 1905, by act of the Tennessee General Assembly, whereas there are grave doubts as to the location of the state line between Georgia and Tennessee. I asked my friends and my neighbors, what has changed since 1889, since 1905, since 1974, since 1981? What has changed? The answer is nothing. And we still don't have a resolution. Now, friends, we want to resolve this dispute. It is done by interstate compact, the same way we've done with our neighbors in South Carolina, not all that long ago. We resolve state lines between states, but not by one state acting without the other's consent. The time's come for us to do that. I believe this is a fair offer. There are about 60,000 people in limbo, and I don't want to see their lives disrupted any more than you do. And should we take our claim to the United States Supreme Court, their lives, their state citizenship and otherwise, will be placed in jeopardy. I hope my neighbors will take that into consideration when they review this resolution. I do want to leave you with a final thought. There are some who claim that this dispute is exclusively about water. I find that unfortunate. Unfortunate for elected officials in my neighboring communities not to acknowledge that it's also about land and people whom they theoretically represent. People whose lives will be disrupted if we cannot solve this dispute. The offer made in this resolution affects a tract of land that does not have any population. So no people will have to be affected by the resolution. But let's make no mistake about it. The original line was drawn for water. Not for water for Atlanta, but water to engage in interstate commerce. There was no mistake when they drew the original line. The Tennessee River crossed the 35th parallel several times as it made its way west. So they picked the 35th parallel to give the southern states beneath Tennessee and those territories access to what then was the interstate system, the rivers of our country. That was an intentional decision. It's the reason our state line bears north by northwest from Columbus as opposed to due north or otherwise. It is to reach a specific point on a map, the northern shore of the main channel of the Tennessee River. It's always been where the tri-states met from the day they, Alabama and Tennessee, were created. I ask you to favorably consider this resolution, and I urge my neighbors to consider carefully the consequences of their failure to do so next time they have the opportunity. Mr. President, I yield the will.
Chair recognizes the senator from the 50th to speak to the resolution.
Mr. President, members of the Senate, I just want to make a few brief comments in support of House Resolution 4. It does have implications for other parts of the state, not just Northwest Georgia. I would like to point those out. It's very important to me that this resolution would protect the Savannah River. It would remove the need for interbasin transfers from the Savannah River to provide water for Metro Atlanta. It would also protect the Savannah River and the Savannah Harbor and the dredging project that's going on in Savannah at the present time. Also, another area that's near and dear to my heart, it would also protect the farmers and agriculture in Georgia by increasing the water supply for Metro Atlanta and augmenting the various river basins south of Atlanta. By doing this, it would provide more water for Georgia's farmers, more water permits would be available, and House Resolution 4 would help drought-proof Georgia agriculture and agribusiness. So with that said, I would urge your support of H.R. 4. Thank you, and I yield the will.
Chair recognizes senator from 33rd on the resolution.
Mr. President, ladies and gentlemen of the Senate, I had the opportunity to work with the North Georgia Water District when I was administration floor leader for Governor Barnes. Water, of course, is one of the primary resources that in the future is going to make a difference one way or the other for the growth of Georgia and the quality of life that we have. We have 15 river basins, I think. And as it relates to the Northwest Corridor, let me say that I had the opportunity the other day. My little twin grandsons were turning 4, so I went to Chicago to enjoy that with them. Got an earache, couldn't fly back, so I drove back. And if you've ever driven through that area that this resolution addresses, I was welcomed by Governor Deal 3 times within 10 miles. And also said, please come back 3 times within 10 miles. The 1818 survey of that 35th corridor, 35th parallel, is without a doubt drawn for a reason, and I think the floor leader expressed the reason to you. That is because it was drawn for other states below the Tennessee line. Now, it looks like to me that the President pro tempore has drawn a bill or a resolution that is fair, that will require us to be good stewards of the water. It also, I think, is fair to Tennessee. I don't think they're asking for the whole pie, which we have a right to. So I would be very interested after we pass this to see how Tennessee reacts to it. We know there's some great, great folks in Tennessee, and we hope that they'll work with us. But this is, I guess it's one of those things that's so much more important than it sounds like. Somebody told me the other day, they said, no wonder they laugh at the South. Y'all can't draw a straight line. Well, that line was drawn a little unusual on purpose, and it was to serve all of us. So some of these things are just so much more important than they sounded in the beginning. It's more than just a dispute, it's quality of life in the future. And I commend the representatives across the hall and ask that you would join the President Pro Tempore and the floor leader in voting this affirmatively out of the Senate.
Question is on the adoption of the floor amendment authored by the senator from the 48th. Is there objection? Without objection, the floor amendment is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report, which is favorable passage of the resolution? The chair is none. And all of those in favor of the resolution will vote aye. Those opposed, no. Secretary, unlock the machine. On the adoption of the resolution, the yeas are 48 and the nays are 2. And this resolution, having received requisite constitutional majority, is therefore adopted. We have some local bills that we need to read and assign.
House Bill 633 by Representative Wilkerson of the 38th, a bill to be entitled an act to amend an act creating a new charter for the city of Powder Springs and for other purposes.
Slow go.
House Bill 640 by Representative Dutton of the 157th, a bill to be entitled an act to amend an act creating a new charter for the city of Glenville and for other purposes.
State and local governmental operations.
House Bill 653 by Representative Chokas of the 138th and others, a bill to be entitled an act to amend an act creating the State Court of Sumter County and for other purposes.
State and local governmental operations.
Through with the order, Mr. President.
Chair recognizes Senator from the 49th.
Mr. President, I move that we adhere to the substitute, the Senate adhere to its substitute of House Bill 487 and a conference committee be appointed.
Read the caption.
House Bill 487 by Representative Ramsey of the 72nd and others, a bill to be entitled an act to amend Chapter 12 of Title 16 of the OCGA relating to offenses against public health and morals so as to correct a cross-reference and for other purposes.
Is there objection? Without objection, the chair appoints the senator from the 47th, the senator from the 54th, and the senator from the 45th. His conferees, 47th, 54th, and 45th. Excuse me. Look, I kept thinking, well, why is this? Your handwriting is poor, and my eyesight is too, Bob. 49th, 54th, and 45th. Secretary will read House Bill 116.
House Bill 116 by Representative Dixon of the 6th and others, a bill to be entitled an act to amend Article 1 of Chapter 2 of Title 20 of the OCGA relating to the State Board of Education so as to authorize the State Board to transfer donations, gifts, and other property and for other purposes. The Committee of the Senate on Education and Youth recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes Distinguished Education Committee Chairman, the Senator from the 37th. Present the bill. Secretary will read the amendment.
Amendment 1, Senator Henson of the 41st and others offer the following amendment. Amend House Bill 116 by inserting after State Board on line 40 and Education on line 57 the following, up to an amount or a value not to exceed $100,000 per year.
Chair recognizes Senator from the 37th.
Thank you, Mr. President. Members of the Senate, I bring you House Bill 116. This is a very simple bill in that it takes funds that have been designated and donated to the state BOE and authorizes them to transfer any donation, gift, devise, or bequest of real, personal, or mixed property held in trust by the BOE to the Georgia Foundation for Public Education. These provisions of this bill will also extend these trusts authorized by statute for the Georgia Academy of the Blind, the Georgia School for the Deaf, and the Atlanta Area School for the Deaf. The beauty of this legislation is it consolidates somewhat all of the giving held in trust for educational purposes in the state of Georgia for K through 12. It also would give a very clear vehicle by which there could be directed, designated giving of a philanthropic nature, people who would have a project that they would like to see happen. If there is agreement that the project could be completed, these funds could be given in the form of an advise and consult fund through the foundation, and it would not have to be handled, administered, invested, or so on through the DOE. The foundation is in the business of managing these funds, and it just makes a lot more sense to do that. I'd urge your favorable consideration of this bill. I think it's a very good bill. Mr. President, if there are no questions, I'll yield the well.
There is one question. Chair recognizes Senator from the 33rd for a question.
Senator Yield.
Yes, sir.
Mr. Chairman, I was going to ask you, this would require it to be used for the specific purpose for which it's intended. Is that correct?
Would not necessarily be required. Someone who could just give an estate to the foundation. It could be designated or undesignated to be used for educational purposes in the state. But this would allow the use of designated giving, and generally speaking, if our intent is to encourage philanthropic giving, if we have that mechanism, people are more likely to give to a specific purpose if they can be guaranteed it's going to that.
Right. You further yield?
Yes.
Yeah. What I'm saying to you, my question is, if it is directed and for a specific purpose, then the trust or the educational foundation would use it for that purpose.
Absolutely. It'd be earmarked for that, but they could also reserve the right to, or from the authority that it's being received on behalf of, if a particular school, if someone said, I want to give money for a particular purpose, if the school says it's not feasible for us to do that, they could refuse the gift as well.
Chair recognizes Senator on the 45th for a question. I'm sorry, 54th.
Thank you, Mr. President. Will Senator yield for a friendly question?
Absolutely.
Is it not true that the State Board of Education would retain ultimate authority over the distribution of the funds that came out of trust?
Well, actually, the destination of the funds would even be more clear if it's going to the foundation. They would be given through DOE into the foundation. But I think as it currently stands, monies coming in of a general nature would go into the state budget, and this would put more of a firewall as to the guarantee these funds would be for a specific purpose.
Thank you, Senator. Will you yield for one more question?
Yes.
My question is, when the funds come back out from the trust, would not the State Board of Education be directing the expenditure there as well?
Absolutely. I mean, they do not have the authority to redirect these funds against the donor's request.
Thank you, Senator. Thank you, Mr.
No further questions, Senator. Chair recognizes Senator from the 41st to speak to his amendment.
Mr. President, members of the Senate, I do have some concerns about this bill, personal concerns that right now you can donate money to the Board of Education, and that money can be designated for different purposes. The foundation is under a much more lax standard. They do not have to live up to the state procurement policy, Title 50. They don't have to live up to the state disposal property of any financial or other items. So basically what we're doing is transferring funds to an agency that has a much less protective nature and does not have to abide by state statutes on procurement policies, on disposal policies. Number two, right now anybody who wants to donate money can donate directly to the foundation and be tax exempt. So if we're talking about donations made today, this is kind of disingenuous because you can make those donations, if you should so decide, directly to the Georgia Foundation and not to the state. People who elect from this day forth to do so to the state may do so for a reason. They may wish to have those follow the state guidelines and state laws that are applicable for the Board of Education. So therefore, I would urge you to vote against this bill. This bill is primarily because there are some funds in the Board of Education, and it wasn't even brought up to you, that there were some funds in the Board of Education that were brought to us before this law was created in 2010. And they want to be able to transfer those funds to the Board of Education Foundation, the foundation rather from the board. And my thoughts are these. If in the future all funds could be directly donated to the foundation, that people want donated foundation, then why do we really need this law? Two, the foundation is not governed by the same restrictive authority that the Board of Education is governed by. And therefore, I think it is not in the best practice to do that, because if somebody wants to donate to the Board of Education, they can. If someone wants to donate to the foundation, they can do that, and the foundation donations are tax exempt. I would urge you to think twice before you vote for this. There is also concerns, and I heard it stated from the well, that if I donate a property for a specific purpose, that the foundation will comply to that purpose. I believe it would be their intent. I know members of the board, I think Bill Dahlberg used to live in my area, very, very great people on the foundation board. But I don't think that they are restricted as the Board of Education would be in that intent. And I urge you to vote against this bill because, again, it is not necessary. If you want to donate money to the foundation, it would be tax exempt and you can do so. You shouldn't have to, believe this story that we want them to donate to the state so they can transfer it to the foundation so it can be better managed. If you want to bequest to the foundation. I'm happy to yield for questions, but I have an amendment that would limit any transfer from the State Board of Education to $100,000 or less. And that would be a prudent thing to make sure that we limit large transfers out of the Board of Education that presently exist to a reasonable amount, considering the foundation, again, is not governed by the same state laws. Expressly in the legislation passed in 2010, they're not required to follow the procurement policies nor the disposal properties of assets that the state does. And if there is some concern that some present state assets that were given to us as a gift or a bequest could be invested better by the foundation, I would say that's a minimal concern to the concern of protecting what assets we have and making sure we act properly under the Georgia statute. I yield for questions if there are any.
Chair recognizes Senator from the 37th for a question.
Senator, do you yield?
I yield.
Is it not so that the foundation has more legal grounds to earmark funds for specific purposes than money given to the DOE that would be in the state general fund?
I don't believe so. I believe the state, and another colleague here asked a question about wouldn't the state be the one, the Board of Education be the one directing where the foundation sends the money. The board of the foundation would have the authority to direct the funds, and they could, by rule, bound themselves by the bequest requirements, but they are not bound by state law to honor any purpose or designation of the bequest.
Is it not true that they could bind themselves, but they could not bind the funds if they were given to the state DOE, as in the case of the foundation? If they set up a directed giving program with an advise and consult fund, those funds would absolutely be secure for the purpose for which they're given. Is that not true? That
is not true under state law. It is true if the board foundation so approve in their guidelines and purpose, but that could be changed by a future board.
I don't believe they could if it was in the guidelines of the original gift. And is it not true that if you limit the gifts to $100,000, we would be discouraging philanthropic purposes other than encouraging them in the state?
Absolutely not. And I believe, as stated, people can donate now to the foundation. So you would not be discouraging it, because people who want to make the donation to the foundation would do so. It would be tax exempt. That is not the purpose of this legislation.
There are those that disagree with you. Thank you, Senator.
Chair recognizes Senator from 22nd for a question.
Thank you, Mr. President. Senator Yield.
I yield.
Senator, is it not true that the foundation is not bound to set or establish education policy?
That is correct.
Does the senator further yield?
I yield.
Senator, are you aware of whether or not the foundation is a 501c3 organization?
It's not a 501c3. It's a 170. Maybe the Senator for 37 can help me, but it is a tax-exempt group, but it is not a 501c3, I do not believe.
Does the senator further yield?
I yield.
If it is a tax-exempt group, if donations, contributions, et cetera, are made to this organization, is there an ancillary benefit to the donor by way of tax exemption? If we donate?
If someone donates to the foundation directly, it is a tax-exempt organization. You would get a tax break for it.
Does the senator further yield?
I yield.
Senator, you've established that the foundation is not bound or set up to set or establish education policy. With that being said, is it not true that they then also would not be better suited to distribute and or allocate education dollars?
Would the foundation or the Board of Education be better suited?
The Board of Education is better suited.
The Board of Education certainly would be the direct instrument that would follow the guidelines of the state board. The state foundation certainly are not, or a subset, not administratively connected to the Board of Education, but not directly a part of the state. They are not a state entity directly. Their board is appointed by the superintendent and the Board of Education separately. I think the Board of Superintendent gets 2 to every one that the board gets. And they meet very high standards, but I think the Board of Education would be certainly the one directing our state policy at the very top, and therefore be in probably the best posture in most cases to expend money.
Does the senator further yield?
I yield.
Senator, in Section 2 of the bill, lines 53 through 56, it speaks specifically to the issue of supporting educational excellence at what we know to be schools that have been identified as special schools: the Georgia Academy for the Blind, School for the Deaf, and then, of course, Atlanta School for the Deaf. Is it not true that the Department of Education is better suited and, in fact, better able to not only administer education dollars as well as establish education policy for those institutions?
I think that is absolutely correct, Senator.
Does the senator further yield?
I yield.
And with that being said, would it also then be reasonable to assume that this measure is not needed?
Absolutely, and certainly not needed for any of the reasons presented on the floor today. I can assure you of that.
No further questions, Senator.
Thank you.
Question on the adoption of the floor amendment authored by the senator from the 1st. Is there objection? There is objection by the education chairman. All those in favor of amendment number 1, rise, stand, and be counted. If you are in favor of amendment 1, rise, stand, and be counted. They've got it. Reverse. On the floor amendment, the yeas are 15 and the nays are 32, and the amendment has lost. Does any other senator wish to speak for or against the bill? Is the objection agreed in the Porter Committee which failed to pass the bill? Chairs none. Porter Committee is agreed to. Shall the main question be now put? Are there any objections? The chairs none. The main question is ordered. Shall this bill now pass? The question is on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. Like for the Senate to welcome the President Pro Tem as he begins to preside over the Senate. Go easy on him.
Do I declare that the bill passed? Okay. What do I say when it passes? Will that come up?
Opportunity knocks. Your time has come.
I got you. On the passage of the bill, the ayes are 42, the noes are 11. The bill having received the requisite constitutional majority is therefore passed. The Secretary will read House Bill 161.
House Bill 161 by Representative Atwood of the 179th and others. A bill to be entitled an act to amend Part 1 of Article 5 of Chapter 12 of Title 15 of the OCGA relating to trial juries in general so as to change provisions relating to oath of bailiffs and for other purposes. The Committee of the Senate on Judiciary recommends that this bill do pass. Through with the order, Mr. President.
Senator Williams. I'm sorry.
Oh.
Senator from the 19th.
Mr. President, could I move the committee of the whole?
The chair recognizes the senator from the 3rd District to speak to the bill. Senator from the 3rd.
Thank you, Mr. President. It's House Bill 161 amends the oath which bailiffs must take before they take charge of juries by deleting some old language which says that they're to deny the jury of meat or drink and replacing that so that they're not to be given any, take books or electronic equipment or food or that's right, or liquid except for water into the jury room. Unless there are any questions, Mr. President, I'll yield the well.
Are there any questions for the senator? If there are no questions, the senator is excused. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote aye. Opposed, no. The secretary will unlock the machine. Passage of the bill, the ayes are 52, the noes are 0. The bill having received. On the passage of the bill, the ayes are 52, the noes are 0. The bill having received the requisite constitutional majority is therefore passed. For what purpose does the senator from the 33rd rise?
Is it not true it would be appropriate for me now to make a motion to reconsider our action?
That motion would be in order if you really want to make it.
Well, actually, he's fair. I'm going to hush.
The secretary will read House Bill 192.
House Bill 192 by Representative Kidd of the 145th and others. A bill to be entitled an act to amend Code Section 43-35-3 of the OCGA relating to definitions regarding podiatry practice so as to provide that podiatric medicine includes the diagnosis and treatment of cosmetic conditions and for other purposes. The Committee of the Senate on Health and Human Services recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes the senator from the 52nd District to speak to the bill.
Thank you, Mr. President. This bill revises the definitions for podiatrists that will allow them to treat cosmetic conditions as well. It's currently being done, but it helps with the coding so that while they're there doing things, if there's blemishes, that they can go ahead and take care of them as well. This is, has no opposition and is supported also by the Medical Association of Georgia. And if there's no questions, I'll yield the well.
There are no questions. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears no objection. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote aye. Opposed, no. The secretary will unlock the machine. On the passage of the bill, the ayes are 47, the noes are 3. The bill, having received the requisite constitutional majority, is therefore passed. The Secretary will read House Bill 193.
House Bill 193 by Representative Stevens of the 164th, a bill to be entitled an act to amend Code Section 48-8-3 of the OCGA relating to exemptions from sales and use tax, so as to provide a new exemption from state sales and use tax only for a limited period of time and for other purposes. The Committee of the Senate on Finance recommends that this bill do pass by substitute. The Senate Finance Committee offers the following substitute to House Bill 193, a bill to be entitled an act to amend Code Section 48-7-40.26 of the OCGA relating to state income tax credit for film, video, or digital production and for other purposes. Through with the order, Mr. President.
Chair recognizes the senator from the 8th District to speak to the bill.
Thank you, Mr. President. Rise for House Bill 193. This is the food bank exemption bill, if you will. It benefits food banks around Georgia by giving them a sales tax exemption on prepared foods and donated items and relief efforts and so forth. Also gives tax relief to community health centers around Georgia. Many of you know those as the federal qualified health centers or as community health centers. It also allows a sales tax break on the volunteer health clinics. In addition, it also added in the committee was a sales tax holiday will be moved a week from August 9th, 10th to the 2nd and 3rd, where the sale will be prior to school starting. And the last thing is a pass-through on tax credits was added to help small production companies around Georgia. That is House Bill 193. It passed the House 177 to nothing. I ask for your favorable consideration. If any questions, Mr. President, I'll be glad to yield.
The senator from the 39th District is recognized for the purpose of asking a question.
Will Senator yield?
Yes.
The questions I have are regarding the film production part of this bill. Senator Yield, is it not true that we have a tax credit program for film production companies, and what this bill does is create a pass-through so those companies can sell that through a pass-through to other companies? Is that not correct?
That's correct.
Is the program that we presently have for these film production tax credits, is that a pretty successful program as far as you know?
Senator, it's been very successful. As you know, the film industry has become a multi-billion-dollar industry in Georgia. In fact, I heard somebody the other day call us the Hollywood on the East Coast, so it has been very, very effective. You are correct.
Will the Senator further yield?
Yes.
And presently, it's been successful by virtue of those film production companies taking that tax credit for themselves. Is that not correct?
Correct.
So, if the Senator will further yield, my question is, at this point, giving those companies the ability to sell those tax credits to a third party, which is may or may not be, most likely will not be a film production entity. While it's successful now, is that really necessary?
Well, I'll leave that for each senator here to make that decision, but I think it will help the small production companies around this state. You know, we have quite a number of those small film companies, and I think it'd be a benefit to the smaller companies, quite frankly, in the production industry.
Yes, sir, I'm sorry.
Yes.
Will the Senator further yield?
Yes.
One last question. What amount, presently, well, for the last fiscal year, do you know how much those tax credits amounted to that we gave those film production companies?
I do not have a number on that, Senator. I'm sorry.
All right. Thank you.
Mr. President, no other questions. I yield the floor and ask for your favorable consideration.
No further questions. No further questions. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the passage of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill pass now by substitute? The question is on the passage of the bill. All those in favor of the bill will vote aye. Opposed, no. The Secretary will unlock the machine. On the passage of the bill, the ayes are 47, the noes are 4. The bill, having received the requisite constitutional majority, is therefore passed. The Secretary will read House Bill 208.
House Bill 208 by Representative Watson at 166th and others. A bill to be entitled an act to amend Article 1 of Chapter 7 of Title 31 of the OCGA relating to regulation of hospitals and related institutions so as to require nursing homes to annually offer influenza vaccines and for other purposes. The Committee of the Senate on Health and Human Services recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes the senator from the 40th District to speak to the bill.
Thank you very much, Mr. President. HB 208 requires nursing homes annually to offer flu vaccines to its employees who have direct contact with patients at no cost to the employees. They've got to keep a record of signed statements from the employees indicating whether or not the employee accepted this or declined this vaccination. And finally, the bill limits the liability of the nursing homes who comply with these requirements in good faith. I'll be happy to answer any questions, Mr. President. Thank you, Mr. President.
Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question now be put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. The Secretary will unlock the machine. On the passage of the bill, the ayes are 44, the noes are 9. The bill, having received the requisite constitutional majority, is therefore passed. Yes, sir. The Secretary will now read House Bill 210.
House Bill 210 by Representative Nimmer of the 178th and others. A bill to be entitled an act to amend Code Section 48-8-17 of the OCGA relating to temporary suspension of the collection of taxes on gasoline and aviation fuel so as to provide for legislative findings and for other purposes. The Committee of the Senate on Finance recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes the senator from the 17th District to speak to the bill.
Thank you, Mr. President, members of the Senate. House Bill 210 simply ratifies the governor's executive order last summer that froze the gas tax rate. And I ask for your favorable consideration. And Mr. President, if there's no questions, I'll yield the well.
Senator from the 26th District is recognized for the purpose of asking a question.
Gentleman, Senator in the well, will you yield?
Yes.
Why is it we didn't start this bill over here in the Senate?
I couldn't hear.
I said, why is it that we did not start this bill over in the Senate?
I'm not sure. Started in the House.
So you
tax bill.
Beg your pardon?
I guess it's a tax bill.
It's a revenue bill.
Revenue bill.
I just wondering because the Medicaid bill was a revenue bill.
No other questions. Does any other senator wish to speak for or against the bill? Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question now be put? Is there any objection? Chair hears none, and the main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. The secretary will unlock the machine. Senator from the 42nd. Senator from the 42nd.
Parliamentary inquiry?
Yes, sir.
Is it not true that since you've taken the gavel, this has been the smoothest that the Senate has operated all year?
On the passage of the bill, the ayes are 52, the noes are 0. The bill, having received the requisite constitutional majority, is therefore passed. The secretary will read House Bill 246.
House Bill 246 by Representative Golick of the 40th and others. A bill to be entitled an act to amend Article 1 of Chapter 9 of Title 10 of the OCGA relating to general provisions for the G.O.L. Smith II Georgia World Congress Center Authority, so as to provide that the authority shall have the power to provide benefit programs to its officers, employees, and other agents, and for other purposes. The Committee of the Senate on Insurance and Labor recommends that this bill do pass by substitute. The Senate Insurance and Labor Committee offers the following substitute to House Bill 246. A bill to be entitled an act to amend Article 1 of Chapter 9 of Title 10 of the OCGA relating to general provisions for the G.O.L. Smith II Georgia World Congress Center Authority, and for other purposes. Through with the order, Mr. President. Amendment 1.
A late arriving amendment.
Senator from the 28th offers the following amendment. Amend the Senate Insurance and Labor Committee substitute to House Bill 246 by inserting after authority on line 7 the following. To amend Code Section 45-18-2 of the OCGA relating to the authority of the Board of Community Health to establish health insurance plan, rules, and regulations, and for other purposes. Through with the order, Mr. President.
Chair recognizes the senator from the 8th District to speak to the bill.
This legislation very simply gives the World Congress Center the ability to opt out of the Flex Benefit Program. And that's all it does, and I ask for your favorable consideration. If there are no questions, Mr. President, I yield the well, and I have not seen the First Amendment. So.
Okay, there are several questions. The senator from the 49th District is recognized for the purpose of asking a question.
Wave it off.
Senator from the 26th District is recognized for a question.
Senator Yield.
Yes.
Senator, with the World Congress Center opting out of the state health benefit plan, would it not be wise that the members of the General Assembly ought to come up with a program to opt out of the state benefit plan that would give us a better plan than what we have?
No, this is opting out of the flex benefits. This is the supplemental insurance. They already are out of the health insurance side. They've been exempted out of the state health benefits, Senator, for some time. This is only allowing them, they are now under their own. This is only allowing the supplemental side, which employees choose whether they want it or not. So they had to have legislation to do this, and it brings them in line. They're already out of the state health benefits.
Would Senator yield again?
Yes.
Well, Senator, if they are out of it, why is it that we are still in it?
Well, I'll leave that to every member in here to decide that question. But as I said, Senator, let me make clear, they're not under the state health benefit plan. And all they want to do under this bill is opt out of the flex benefits, which is supplemental policy. So,
Senator yield again?
Yes.
Senator, don't they have a better plan than we have on the state health benefit plan?
I have no knowledge of that, Senator. That would be to each member to decide. No other questions, Mr. President? I yield the well, and I'll be honest with you, I've not seen the First Amendment.
The senator from the 41st District is recognized for a question.
Would the senator yield?
Yes.
Senator, how many employees are there that would be affected by this change?
I believe that's 420 employees of the World Congress Center.
And what was their intent or purpose in requesting this change? Is it they feel, and maybe you could tell us a little bit about what these flexible supplemental benefits are. I have no idea. Is their intent that they want to go find another better plan for less money? Is it because they want to decrease the amount or offerage to the employees to save money?
I think, senators, quite frankly, they just want to test the market. As I said to the other senator, that they're not under the health benefit plan now, and they wanted to come out from under the flex benefits, which is supplemental stuff. And so they had to ask for legislative authority to do that. That's all this bill does.
And the senator would further yield, this is authorizing them to get out if they want to, but doesn't mandate it. In other words, if they, as you say, check the market, they can stay in if they so choose.
They could stay in. They could stay in if they want. It just gives them that option.
And just one example, what would be one of the flex benefit policies?
It'd be a cancer policy. It'd be an accident policy. Those are your supplemental policies that the employee pays for. They choose whether they want it, and they pay for it themselves. That's an example of dental, eye, vision. Those are flex benefits. Mr. President, there are no other questions. Like I said,
I'm sorry, the senator from the 33rd is recognized for a question.
Chairman Yield.
To my friend, yes.
Let me ask you, sir, on the front page, it reflects in the underlined language as the new language in that section. It describes employee benefits described in Code Section 45-1852. But we don't have that language of that particular code section shown to us in the bill. That's not unusual. But is it true that this Employee Benefits Council is one that would relate to others, to other insurance examples in the state? Do you know what Section 52 does?
No, I really don't, Senator. I'm like you. A lot of times those are in the bill for explaining other sections of the law. Again, this is a very straightforward proposition. They're just opting out if they want to out of the flex benefits. As I said, they're already out of the other health benefits.
Senator Freddie Yield.
Yes.
And I won't belay this because I don't want to cause any trouble on it. This is simply, it reads on lines 17 and 18, fix that compensation and establish a flexible employee benefit fund for the authority employees, which may include those flexible employee benefits described in Code Section 45-1852.
I know what that is,
Senator. That pretty much as simple as a flex?
Senator, that's describing the flex benefits. I'm sorry. Now that you read that, that's exactly what that section does.
I thought you
And that's when the Senator in the 41st asked that question, it describes what they are.
Thank you very much. I thought that was it. Thank you.
Senator from the 9th District is recognized. Senator from the 9th waves off. There are no other questions, Senator.
All right, let me review the First Amendment. Thank you, Mr. President. I ask for your favorable support, and I'll be back on the First Amendment.
Chair recognizes the senator from the 28th District to speak to his amendment.
Thank you, Mr. President, members of the Senate, friends in the gallery. I rise today to offer this very simple one-line amendment that would say that no health insurance plan shall offer cover for abortion services relative to the state health benefit plan. Since 1973, 55 million abortions have been performed in our nation. And since 1973, state taxpayers in Georgia have been paying for them through the state health benefit plan. The numbers we have seen over the last 3 to 5 years have been somewhere between 300 and 500 abortions paid for primarily by taxpayers. And I think that's time that stops. We, as the taxing authority in Georgia, do not have liberty to use that money to end the life of the unborn. Just earlier today in this session, with a huge majority vote, we protected the life of a fish off the coast of Georgia. I expect the same support today for the life of a child. For the life of a child. Back in 2008, a presidential candidate was asked, when do human rights apply to the unborn? Many of you might remember that candidate's response. He said it was above his pay grade. I wonder if it's still currently above his pay grade. It's a rather simple question, I believe. Those rights begin at the point when life begins. And that is not a gray area, my friend, because life most certainly begins at the point in time which you can end it. So I would ask that you would end taxpayer-funded abortions in Georgia by limiting taxpayer dollars going into the state health benefit plan such that they do not fund abortion services. It's very simple. It doesn't outlaw abortion. It doesn't limit people's access to abortion. It just says we will not force the taxpayers of Georgia to pay for it. Friends, I ask your favorable consideration, and may you please support this as well as you support the fish off the coast of Georgia. If you will protect the life of a fish, I challenge you today to protect the life of an unborn child. Mr. President, I yield well.
See, there were questions. Will the senator? The senator does not wish to answer questions. Okay, the senator's yielded the well. The senator recognizes, the chair recognizes the senator from the 33rd district to speak to the bill.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I'm sorry that my colleague decided not to take my question. He's got the right to do that. In fact, sometimes I wish that I would take my own advice. But let me say this along in a serious way. As I read the amendment, it doesn't provide for a procedure to take place when someone is insured, whether it be a spouse or a state employee, if it was endangering the life of the mother. I don't understand why the state taxpayers wouldn't. I don't think most taxpayers would mind us covering our folks to save the life of a mother if the pregnancy has gone in a direction that they wished it hadn't. And that was my question for him. Had nothing to do with fish. But I think maybe it's not written as well as it could be. But I've written a few worse. So thank you for hearing me out and letting me ask that question to you all.
Let's see, there were questions. Did you wish to yield for any questions? Okay. The senator's yielded the well. We'll suspend for just a moment. We have a second late arriving amendment. The clerk will read the amendment.
Amendment 2 by Senator Hill of the 32nd. Amend the Senate substitute to House Bill 246 by inserting in Section 3, no abortion coverage shall be provided by a qualified health plan offered through a state or federal law or regulation within the state of Georgia, and renumbering accordingly. Through with the order, Mr. President.
Who's the author? 21. Chair recognizes the senator from the 32nd District to speak to his amendment.
Senators, I bring to you what is the language of Senate Bill 98, which is also a prior bill from last year. And what it does is to say this, is that it's wrong in the state of Georgia to require other people to pay for someone else's abortion. This is not about whether abortion's right or wrong. You look at the language, actually, of Senate Bill 98, and it actually speaks that it doesn't talk to the right to have an abortion as it's required and allowed under federal law, but as to who pays for it. I don't believe it's right in this state to make my family pay for somebody else's abortion or someone else's family to pay for anybody else's abortion. And that's what this gets to. My amendment number 2 speaks to, under federal law, we are today in the state of Georgia paying for abortions through our state health benefit plan, and we're also paying for abortions out of federal dollars. And if we expand this, if we take the Medicaid expansion that many across this state and across this country would argue that we do, and I think that's wrong for the people of this state, by the way, but if we took Medicaid and expanded Medicaid, or if we created a state-based or a federal-based Affordable Care Act, which I would suggest is the Unaffordable Care Act, by the way, but if we took Medicaid or if we expanded into exchanges, then all Georgians would be paying for abortions for other people. And I believe it's fundamentally right for you to have the right, you as senators and you as representing about 10 million Georgians, to have the right to say no and how your dollars are spent. And that's simply what simply what Senate Bill 98 does. That was sponsored earlier this year, that didn't have a hearing, and that's what my amendment does. I support amendments 1 and 2, and to the extent that there's a ruling from the president, then I would support whatever the ruling is from the president. But I think it's important that the people of the state of Georgia be freed from the mandate of paying for someone else's right to take a life of an unborn. Thank you very much.
The senator has questions. Will the senator yield for questions?
I'll yield.
The senator from the 39th District is recognized.
Yes, Senator.
Will the senator yield?
Yes, I do.
I do not have the Second Amendment in front of me. Can you explain how your amendment differs from the First Amendment?
Can you give me a copy?
As we wait for its arrival? Okay, here you go.
I've got a copy of amendment number 1, which I believe is before you. It says no health insurance plan shall offer coverage for abortion services. My amendment, I don't have it in front of me, the copy, but it's the identical language of 98, which says that no health insurance plan offered in the state of Georgia through state or federal plans can offer abortion coverage. And specifically, it's delineated in the language of the amendment. But the difference is this. Amendment number 1 is narrower to state funded plans, and my amendment is broader and would encompass plans that are offered through the Department of Community Health, which would be the Medicaid expansion and would be the Obamacare application through exchanges and other plans currently in Georgia that are funded by federal law, and those exist today as well through Medicaid. And currently today we're spending a number of abortions are being performed today, last year, the year before, the year before, the year before, and so on, funded currently. This is not speculative. This is not speculative. Currently, there's monies coming out of our taxpayer funds to pay for these abortions, and I think it's wrong, and that's the purpose of my amendment, and I applaud the senator from the 28th and all his work as well.
You've asked your question, Senator, or you have another more time?
Point of order, Mr. President.
Yes, sir.
Can the president rule on the germaneness of amendments 1 and
not while this senator's in the well. Are there any questions for this senator? Any other questions for this senator? So I'll recognize the senator from the 35th district for a question.
Will the gentleman yield?
The senator yields, yes, ma'am.
Senator, can you, the senator from the 32nd, or the senator, can you have a baby?
Can I have a baby?
Uh-huh.
Can I deliver a baby?
Can you have a baby?
Last I checked, no, except by the act of God, and he did that over 2,000 years ago, and I think that's the first. I know that to be the first and only time whose death and resurrection we celebrate later on this week as my Savior and Lord.
Will the senator further
I do yield.
Senator, I understand that you don't want your insurance dollars being spent on certain things, but are you going to also add a ban on Viagra and on vasectomies?
A ban on Viagra and vasectomies, I don't know about those either, just like I don't know nothing about birthing no babies, but
are you going to ban it?
Right now I'm not sure how our funds are utilized in our health benefit plans, but I'm saying
yes,
we're not speaking towards the right to have an abortion or not as it's allowed currently in this state or under federal law. We're speaking to who's paying for it, and I don't think it's right to make my family pay for it or your family pay for somebody else's elective procedure. And with that, I'll yield the well. Thank you, Mr. President.
Senator there's other questions, but the senator has yielded the well. Senator recognizes, the chair recognizes the senator from the, I'm sorry. Senator doesn't have his light on. You have yours on to ask a question.
A point of order,
Senator
Mr.
from Atlanta is recognized.
I just wanted to ask for a ruling on the germaneness of amendments 1 and 2.
Okay, we're looking at that right now. We'll suspend for just a moment. The chair is prepared to rule on the germaneness of the amendments. In the opinion of the chair, Amendment 2, which deals with insurance that is not that is beyond the scope of employee benefits, is not germane. In the opinion of the chair, Amendment 1, which deals with employee benefits, which is the underlying subject matter of House Bill 246, is germane. Senator from the 33rd is recognized.
Mr. President, at the present time, I'd like to make a motion that House Bill 246 and all amendments attached thereto be laid on the table.
The motion is in order. It's not debatable. All those in favor of laying this bill and the amendments on the table signify so by voting aye. Those opposed, no. The secretary will unlock the machine. The ayes are 20, the noes are 27, and the amendment, the motion fails. So we will proceed with consideration of House Bill 246. Senator Ort, did you have for what purpose are you requesting to be recognized? To speak to the amendment. Okay, then you need to push the other button. The chair will recognize the senator from the 34th to speak to the bill. Senator from you had pushed the wrong button. You had pushed the button. The chair will recognize the senator from the 36th.
Thank you, Mr. President. Colleagues, I will submit to you a number of points in opposition to this amendment. And I guess the first one, I would point out that we had extensive debate, a tumultuous exchange several times in this chamber and the chamber across the way last year on an abortion bill. The author of that bill is not with us this year. He was not returned to his seat by his voters. I suppose most of you know that, but I just wanted to remind you in the event that you did not. The voters did not see fit to return him to his seat, and they in fact replaced him with a woman who votes now for that district over in the House chamber. So it's a cautionary note. We are at a moment in the history of this nation where, and there's been a lot of discussion over the last year or so about the war against women. There's a lot of women who view the majority party unfavorably because they feel that they are constantly being dictated to about their personal health decisions and their health options. So that's just a point or two around the politics of this. You also remember infamously the people who lost their bids, the front runners who fell to last place and failed to win their bids for the U.S. Senate when they opined extensively on women and their bodies and pregnancy and the state thereof and what should and shouldn't be and who can prevent conception after rape by mind power and so on and so forth. I won't quote the names or the states. Missouri comes to mind, Ohio comes to mind, but people who were shoo-ins for U.S. Senate seats lost those seats from taking radical positions on women's access to reproductive health. So your colleague has not done you a great favor in putting this on the floor and putting this on the board, in my opinion. I would state further that this amendment, as it is worded, represents a very radical view of a tiny minority of this country. I would remind you that abortion services are offered for numerous reasons. Abortion services are protected by the U.S. Constitution, the Bill of Rights, the right to privacy. This is a health decision that is a private decision between a woman, her doctor, her family, and her God. I would remind you that abortion services are provided for a number of reasons, and that is why historically there has been language in our laws dealing with the health of the mother, the life of the mother, the mental state of the mother, I would remind you as well that there are pregnancies. I think the statistic is close to a third of pregnancies result in a spontaneous abortion. There are spontaneous incomplete abortions that require medical intervention. I had a close member of my family who sadly was faced in the much anticipated pregnancy that they were able to sustain, that only to find out sadly that there was a fetal anomaly for in their medical situation. And they faced a very, very painful decision around obtaining an abortion. Under the guidance of their doctors and conferring with their pastor and with family members, that very close family member of mine made the painful decision they were faced with of seeking abortion services. The point is that a termination of a pregnancy can occur for a number of reasons, can have a medical requirement, can be a highly personal decision when you're faced with whether you're going to proceed with a birth when you have a fetus that's profoundly troubled and is going to be able to sustain possibly very few hours of life, or be born stillborn, or live a month in a very painful and intensive medical intervention situation only to then die. That's not my decision to make for you, nor is it yours to make for me. If it's your grandchild, your niece, your family member, fellow member in your faith community, that's not our decision to intervene and determine whether abortion services should be sought from a medical doctor. And that's a very primary reason that I would urge you to vote against this, because you will be denying people who paid their premium and are insured under our state plan an access for coverage for a service that may be required for any one of a myriad of reasons, and they are not allowed to use their health coverage for that legal medical procedure. So think long and hard if you want to be in the posture of supporting a measure like that. Now, I would add that, and I've served on the Health Committee in the House for 20 years. I've served 7 years on the Health Committee in the Senate. We've been in plenty of conversation over these years about these matters. This is no way to undertake a radical policy change that will affect untold numbers of women and families in the employment of the state, and that could also affect outcomes in the next election. So from both the rawest political reasons to the finely honed medical reasons to the constitutional reasons, there are a myriad of lenses on why this isn't the way to make policy. And you can oppose these amendments while reserving your own personal opinion on who ought to, should ever seek and have an abortion covered. You can oppose this on the grounds that this is not the way. Now, the Georgia World Congress Center has a bill that's important to them and to their employees and to their bookkeeping and their accounting and how they're going to address meeting the flexible benefits needs of their employees. They've got a bill here. Are you prepared to kill that bill that they've worked on by adding these rash and radical amendments that have not been vetted, have not seen the light of day? The author of the bill had not even seen these amendments when he was standing in the well asking us to vote passage on what is an underlying bill that is a perfectly acceptable, matter-of-fact bill. So on a number of grounds, you are you're on solid ground to reject this amendment language. This is not the way to make policy. This is the way to get the state tied up in yet another lawsuit and spend some more lawyer dollars defending something that gets thrown up against the wall and then a stampede starts. So I would urge you on all those grounds, constitutional grounds, the hasty approach to throwing this up on the wall, as well as our own history in recent times of some very poorly considered reshaping of abortion policy that has huge unintended consequences for the families of this state. I would ask you to oppose this amendment and support the underlying bill. I will as well bring to your attention at the proper time amendments to, as we're doing this slapdash, shoot from the hip approach, we will have to bring amendments to try to address the problem with the amendment that is before you. And so we will do that at the proper time. They're being prepared and filed now. I will yield for questions. If there are none, I would ask that we, in our better wisdom, no matter our party, no matter our gender, no matter where we come from in the state, that we would say this is not a way to address a sensitive, delicate policy of this nature that is involved and will lead to have legal repercussions and expenses for the state. If you want this policy to be considered, I say bring it to a committee, put it through the process. Let it survive, withstand the scrutiny. Let's hear testimony from the experts, both on the constitutionality as well as on the medical aspects of this. It is considered by the American public, and I say to you by the Georgia public as well, to be very, very rash and radical to pass abortion policy that has no stipulation for the life and health of the mother. I would thank you and yield for any questions. If there are none, I'll yield the well.
Senator from the 39th is recognized for a question.
Yield.
I yield.
Is it not true that many employees of the state of Georgia are, for all intents and purposes, the working poor that receive such benefits as peach care and other benefits? Is that not true?
Senator, could you speak up just a
I'm sorry.
little bit?
Is it not true that many employees of the state on state health care plans are the working poor receiving benefits like peach care?
That's absolutely correct.
And wouldn't those employees, if this amendment was to pass, wouldn't those employees be effectively discriminated against because they're the working poor not be able, if it's denied through their health care benefits, if these services are denied through their health care benefits, they are in effect being denied because of their economic status?
Yeah, the senator makes a very good point. We haven't given a state employee raise. I believe it's 7 years now. So many state employees are strapped and live paycheck to paycheck. And we have many in the lower tiers of the level of wage that they earn. And when you say to an employee with very limited household income, a state employee who has not had a raise in 7 years, that this procedure is now no longer going to be covered, you are forcing a very painful decision on a family that has a necessity for this procedure.
Thank you.
Yeah, that is an excellent point, Senator, and I thank you for that. If there are other questions, I will yield, but if seeing none, Mr. President, I'll yield the well.
No, there are no further questions. There are no further questions. The senator from the 34th is recognized to speak to the bill.
Thank you, Mr. President and members of the Senate. I rise just to say a little bit about growing up. You know, growing up, I had one brother. He was older than me. And I always wanted to be a part of the boys' club. Then I came to the Senate and I joined. Every cycle, there's a new attack on women. I thought this bill was strictly dealing with, and I was all for it, you know, strictly dealing with giving the World Congress Center an opportunity to make decisions for them on their benefit plan. Now we've taken a left, and we're off again on the attack on women. Let me just start by saying what I've said every year that I've come down here on this same subject matter. And that is, I believe a woman has a right to choose whatever she decides with her doctor that's best for she and her family. I believe in birth, gave birth to 2. Those 2 gave birth to 2 more. Our family believes in birth, but we don't know what every situation is, yet we want to say we don't want tax dollars paying for it. But you know what? A lot of my tax dollars go somewhere I never knew it was going. But we got to make a specific request just for abortions. Why not for all these other things that our tax dollars go for? How about, you know, all the monies that we were supposed to be collecting for one thing and it never saw the light of day for that thing? If we are so prudent we want to keep up with every nickel, dime, and quarter spent, do just that, not just carve out abortions. I think that's just something some of the young men that I happen to serve with want to make sure they don't get through the legislative session anytime without bringing it up. We got to go there, y'all. I mean, we are on the, this is 3 days before we're done. And if we don't go there, we've not done our job. I think it's mean-spirited to even bring it up again. We've been fighting it, and I guess we will continue to fight it for the next 40, 50, 60 years. But I will leave you with this. This is the season when my Lord and Savior arose. There were 2 thieves on the cross. And let me just say, because one of them believed, he got to go to heaven to see his Father because he asked and he believed. Now, I still believe in the Bible that I read that says all have sinned. All. That means the boys club, the girls club, the dogs and cats clubs, everybody, all have sinned. I realize that some can't afford to pay privately for the girlfriends to have these abortions that they are so skeptical about taxpayers paying for. But those that can afford it are still among the have-lotters that continues to spend their money the way they want to in private for the girlfriend so the wives won't find out. But today I rise to say if he can forgive the thief on the cross, he can forgive anybody who asks. Anybody at any point. So regardless of what your sins are, that's between you and your maker, and that's between her and her maker. So let's not take this whole day going through all of these, again, attack on women. Let's stay focused on the bill in and of itself. And let's see, maybe one time we can get through a session without attacking women. Mr. President, I'll yield the well if there are no questions. You still there? I guess I'll stand here till we return. Unless you all, oh, okay, that's the meeting behind the meeting. We have to see what the results are.
Senator, there are no questions.
I'll yield the well.
Senator from the 42nd District is recognized.
Thank you, Mr. President. I would move that we move this bill to the foot of the calendar and take it up after the other business of the Senate is complete.
Is there objection? If there is objection. All those in favor of dropping this bill to the foot of the calendar stand and be counted. It's already begun counting. What do I say? Reverse. The ayes are 12, the nays are, or the noes are 27, and the motion fails. Senator from the 26th is recognized to speak to the bill.
Thank you, Mr. President, and ladies and members of the Senate. Let's try to get it straight. First of all, Article 3 of Chapter 18 of Title 45 does deal with Georgia Health Benefit Plan. But when you look at the bill, 45-18-52 deals with the flex benefit. Now, if any of you in here carry health insurance, if you look on your check, it is separated. Your flex benefit would be your dental, your vision, I call scared insurance, your cancer insurance. and whether or not you carry term life or group life with the state employees. That's what the flexible benefit is. It's listed on your check stub as flexible benefit. Now, while we might be dealing with the Georgia health benefit under the code section, the only thing you're doing is allowing the World Congress Center to pull the flex benefit plan and offer their employees a different plan. If you notice, many of the state agencies now have come off of the state health benefit plan and gone to the private market because they got a better plan with better benefits and less money than the plan that we have. Now, for those of you who are talking about women, first of all, I've not seen one man that could have a baby yet. The other thing, we do have some experimental operations going on where if you want to get a sex change, you can get a sex change. Now, I don't know whether they can give you the hormones so you can receive whatever is necessary to receive that so you can have a baby. But I think what we need to do is be honest and deal with what we are dealing with, and that is flexible benefit insurance. And it's very separate when you look under the code as to what you're dealing with. So while we are sitting here talking about abortion, we are not even talking about health insurance. We're not talking about health insurance as we know it for paying for any procedures or operations. What we are talking about is the flexible benefit plan, which deals with your life insurance, your dental, your vision, and what I call scared insurance, cancer insurance. That's all it does, ladies and gentlemen. That's all it does. If you don't believe me, go upstairs, pull your check stub, and you will see if you got it, it's listed on your check stub, flexible benefit. If you carry life insurance under the Georgia Insurance Benefit Plan, it's under flex. That's where you carry your life insurance for you, your spouse, and your kids if you still have younger folks in your household. That's all this thing does. And we need to move on. Let's move on to something else. To me, it ain't germane. It's not germane, but the reason I would assume that the president ruled it because it deals with the code section, the very code section that flex benefits under, but it's under a different code section. Under the title, it's under the right title, but the code section we are dealing with is only dealing with flex benefits. Mr. President, if there are any questions, I answer questions. If there are no questions, I will yield the way.
See, there are no questions. Senator from the 35th is recognized to speak to the bill. Has the senator from the 35th waved off? The senator from the 14th. Oh, I'm sorry. I see.
You didn't want us to come down the middle, right? Okay. Thank you, Mr. President. You know, we continue to go around this is like a merry-go-round every year. Here we go again. This is another attempt for men who cannot carry a fetus to dictate what a woman can do with her medical needs and decisions. And by the way, this woman is one who pays her insurance premiums just like everyone else and does not tell these people who do not want her to do whatever she wants with her needs, that she does not tell them that they cannot do anything. And she does not come up here and lobby us to try to take away their rights and their decisions. And also, we cannot continue to allow insurance companies and single-minded ones to force women with these dire medical and mental needs to do what they want, not do what they want to do with their bodies. We have a serious concern with the fact that there are many women who are victims of rape or incest, women who discover these fetal anomalies at the 11th hour, and it's already insufficient protection for women's health. I say let the doctor decide. Also, HB 954 fails to provide an exception for serious fetal anomalies. Most pregnant women undergo an anatomy scope ultrasound between 18 and 21 weeks. And if this scan indicates a potential serious complication, the physicians may ask the woman to wait an additional week before returning for additional tests. Imposing a 20-week ban already with no regard to viability could force this woman into a premature decision to terminate rather than having the opportunity to assess concrete medical conditions. And furthermore, it's failing to conclude an exemption for the delivery of serious fetal anomalies, forcing a woman to carry to term a child who may be incompatible with life, would force a family to endure serious trauma, emotional anguish, and unforeseen medical expenses. Believe me, you don't know when something will happen and your medical expenses start going up and away, even if you have insurance. So why are we going to force these women to have babies that are often already, you know from the first scan that something is wrong with them? So I urge you, I'm one who knows what happens out of the blue about medical emergencies and medical problems. If I could have had 20 children, I would have probably had them. My husband and I got married very, very early. I was 18 when I married. And I had the only babies that God gave me were 2. And I'm very honored and privileged to have them, but that was our decision. And luckily, I didn't have any medical problems. I didn't have any rapes or incest to come toward me that I'd have to try to make a decision that where I would have to terminate a fetus. But I don't know how I would have decided. I think that I probably would have had it, but who knows? But that would have been my decision. And that's my insurance that I'm paying, so I think that everyone should have the right to decide. Also, Georgians already, most insurance plans cover abortion, and this bill would take those benefits away. And it would end most, if not all, private health insurance coverage for abortion to this group who is trying to just expand their opportunity to have a decent insurance. Bans on insurance coverage such as these punish women and worsen the barriers that they face to access these services. And finally, I say that a woman should have access to full coverage that she may need regardless of how her insurance is paid for, or how we think about how men who cannot even go through this, what they think. We as Georgia lawmakers should be focused on the economy, on job creation, on preventive health initiatives, et cetera, and instead we're trying to take the rights from a woman once again. I say no. And any woman in this room who does not agree with me, then I say God bless you, because I cannot understand how any of us could vote for this particular amendment. I ask you to vote no on this amendment, be fair, and allow, and plus, this is not even the right time to be bringing this up on this particular bill, in my opinion. It was not germane. It's unconstitutional, it's not right, and I say no. Thank you. I yield the well if there are no questions.
I do have one question, if you'll take it. Senator from the 31st is recognized for a question. Thank you, Mr. President. Does the senator yield?
I yield.
Did I understand you correctly to say that God gave you 2 babies?
Correct.
Do you believe that God is our creator?
Yes.
Do you believe that anyone is created without God's knowledge?
Let me answer it this way. I understand what you're saying, and I already agreed with you. But that's me in my body. I think that I make the decisions on what happens to me is between me and my God and my husband. And I think that every other person should have that because God gave us a free will in what I believe. And so they have to answer for whatever they do. I have to answer for whatever I do. And the law now allows it, and I think that that's the way it should be. Thank you.
Will you yield for a follow-up question?
Yes, sir, I'll yield. Senator.
Do you believe that God allows a baby to be created and to grow within a woman's womb?
Of course I do, yes.
All right, thank you.
You're welcome. If there are no other questions, I yield the will and I ask you to oppose this legislation.
No further questions, Senator. Okay, has the amendment been read? All amendments been read. Read the amendments.
Amendment 1A, Senator Unterman of the 45th offers the following amendment to the Senate substitute the amendment to the Senate substitute to House Bill 246. By adding at the of line 14, remove the period and add, unless needed due to the mother's medical necessity or to preserve mother's life. Amendment 1B, Senator Orrick of the 36th offers the following to Amendment 1. By striking the period at the end of line 14 and inserting, except in the case of medically futile pregnancy. Amendment 1C, Senator Orrick of the 36th offers the following amendment to Amendment 1 by striking the period at the end of line 14 and inserting except to protect the life of the mother. Amendment 1D, Senator Orrick of the 36th offers the following amendment to Amendment 1 by striking the period at the end of line 14 and inserting except in the case of rape or incest. Amendment 1E, Senator Hill of the 32nd offers the following amendment to Amendment 1 by adding at the end of line 14, remove the period and add unless needed to preserve the mother's life. Through with the order, Mr. President.
Chair recognizes Senator. Chair recognizes Senator from the 9th.
President, I move the previous question.
Is there objection? All those in favor of moving the previous question will vote aye. Those opposed, no. Secretary will unlock the machine. Senators, move the previous question.
I see you looking at me when you're not looking at me. What did you have? I had my light on for about 10 minutes and you saw it. You knew what he was going to do. It's all right. I don't blame you, but by God, I won't. Yeah, but now I can't.
But unfortunately, I was off the floor.
No, you were here when you could have recognized me. I'm hurt with you now.
Hey, you better get over it. I've been too damn good.
Me? You? My God, you think I was a member of the Grand Old Party?
Me and you guys. Me and you.
We think that sometimes. I got 5 minutes to back me up on my A's and A's. Just to let you know. Steve. Yeah.
On the motion for the previous question, the ayes are 32, nays are 14, and the previous question is in order and has been passed. Senator from the 42nd, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
Does that motion mean that we don't discuss the newly arriving amendments that were not on the table prior to the motion?
That is correct. Cuts off the debate, and it is before the body at this point for votes. Senator from the 33rd, what purpose you rise?
I move we adjourn.
I don't think you're going to get that. I mean, you send.
I can get a vote on it. Maybe 55-1, but I can get a vote on it.
Senator from the 31st, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
So you were just questioned by the senator from the 42nd about cutting off amendments, I believe, and I think you agreed with him. But prior to that, Amendment 1E had been placed on my desk. So is 1E?
We had all the amendments. 1E has been read and is before the body for the vote. You have 1A, B, C, D, as well as E, which I do not have. E. Or is that C or E? Is that C? Okay, the senator from the 45th, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, when the motion to proceed is made, does that include the motion to also vote on the amendments without discussing the amendments?
No, the senator moved the previous question. The previous question was sustained, and so now there's no more discussion, debate on the issue. So we are now going to vote on the amendments. Okay, this is the posture by which the Senate is in. We are now voting on all the amendments that are before you. Again, that is 1A through, or Amendment 1 along with Amendment A through E. Senator, okay, first question is on Amendment 1A, authored by the senator from the 45th. All of those in favor, you moving the yeas and nays? All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. Just so everyone knows, if 1A passes, we then go to 1B. Senator from the 5th, what purpose you rise? Senator from the 5th? No. Senator from the 45th is recognized. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true that in the last 10 years that I have written almost all of the pro-life legislation in this body?
Senator knows from which she speaks.
And is it not true that this language has been a part of that legislation?
Senator knows from which she speaks. On Amendment 1A, the yeas are 35 and the nays are 10, and Amendment 1A has been adopted. Now we go to Amendment 1B, authored by the senator from the 36th. All of those in favor of Amendment 1B will vote aye. Those opposed, no. Secretary will unlock the machine. Amendment 1B. Chair recognizes Senator from the 45th. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that the language in 1A is much more sufficient than the language in 1B?
I know the senator has great passion for which she speaks. On the motion for 1B, the yeas are 17, the nays are 32, and Amendment 1B has lost. Chair recognizes Senator from the 42nd. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
Does the chair rule on whether the amended language renders some of these other amendments out of order? In other words, we passed 1A. Does that have an impact on 1C or 1E?
I think that ruling has already been. I think the senator is correct after seeking legal counsel. 1C, 1D, and 1E. I'm sorry? Not 1B. 1C, 1D. There's no line 14 on the amendment because of 1A. So C, D, and E, I believe, would be out of order. Just. Okay, the chair's going to rule out C, D, and E are ruled out of order. Now it puts us back at the posture of Amendment 1 as amended. Amendment 1 as amended. C, D, and E are off the table. They've been ruled out of order. All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. One as amended. You are voting on 1 as amended. Chair recognizes Senator from 36. What purpose you rise?
Parliamentary inquiry. Isn't it true, Mr. President, that if we reject Amendment 1, we will restore the bill to its original form and pass it as originally presented by the author?
It wasn't because of that. It was because of the way it was written. It didn't match.
So a no vote will leave the bill as it stands in its original form for passage.
State that again, Senator.
Is it not true that a no vote on Amendment 1 will leave the original bill as presented by the author standing for our consideration? With the...
Yes, yes. That is correct.
Thank you.
On the adoption of Amendment 1 as amended, the yeas are 32 and the nays are 15. And the amendment to floor amendment as amended has been adopted. Now, is there objection to the committee substitute as amended? Without objection, committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is the objection agreed to Porter Committee which failed pass the bill? Chair is none. Porter Committee is agreed to. Shall the main question be now put? Are there any objections? The chair is none. Main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. Senator from the 33rd, what purpose you rise?
I'd like to ask you a direct question, Governor, on a point of parliamentary inquiry.
State your inquiry.
Do you believe that these young women and teenagers make these decisions and that it's very easy for them to make these decisions on this horrible situation?
Senator has great passion for which he speaks.
Well, see, if you'd let me speak a minute ago, you wouldn't have had to hear that. And you might have answered it.
Senator has a right to express his views in this very deliberative body. Senator from 36, what purpose you rise?
Mr. President, parliamentary inquiry.
State your inquiry.
Isn't it true that this kind of action is the furthest thing from deliberative that we can imagine to change a fundamental policy that's been in place for the state since time immemorial? Isn't that not deliberate?
I was off the floor, and I know that things, the tension is a little high, but we're going to bring it back down and get down to the business of the day. On the pass of the bill, the yeas are 34 and the nays are 15, and this bill, AMC Rex Constitutional majority, is therefore adopted. Secretary will read House Bill 274.
House Bill 274 by Representative Burns of the 159th and others. A bill to be entitled an act to amend Article 1 of Chapter 2 of Title 27 of the OCGA relating to licenses, permits, and stamps for hunting, trapping, or fishing so as to regulate the practice of falconry and for other purposes. The Committee of the Senate on Natural Resources and the Environment recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes Senator from the 4th present the bill.
Thank you, Mr. President. Members of the Senate, don't think this will take long. Falconry, as some of you know, is the hunting of quarry with birds of prey. It's a federally licensed as well as state licensed activity. The feds are doing away with their licensing, but are continuing to set the parameters for licensing. The state will take over that licensing. Basically, what the bill does is set into code the process for a person to become a licensed falconry person. Requires a test, requires a 3-stage process to become a master falconry person. This permit will be different. It will be for residents of Georgia, but it also, the bill includes a process for non-residents who want to perform in Georgia as well. It's basically just putting into effect what the feds are requiring us to continue. There's about 179 licensed falconers in Georgia. So, Mr. President, I'd be happy to try to answer questions, but that's in a word, doesn't change anything that's going on now. It basically puts us in the business of being the licensing, the sole licensing processor for the state.
There are no questions, Senator.
Urge your adoption.
Does any other senator wish to speak for or against the bill? Is there objection agreed to Porter Committee which fail to pass the bill? Chair is none. Porter Committee is agreed to. Shall the main question be now put? Are there any objections? The chair is none. The main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill vote aye. Those opposed, no. Secretary will unlock the machine. on the pass of the bill, the yeas are 49 and the nays are 0. This bill, MC Records Constitutional majority, is therefore adopted. Secretary will read House Bill 283.
House Bill 283 by Representative Coleman of the 97th and others. A bill to be entitled an act to amend Title 20 of the OCGA relating to education so as to update and revise terminology and for other purposes. The Committee of the Senate on Education and Youth recommends that this bill do pass by substitute. The Senate Education and Youth Committee offers the following substitute to House Bill 283. A bill to be entitled an act to amend Title 20 of the OCGA relating to education so as to update and revise terminology and for other purposes. Amendment 1. Senator Timmons of the 37th and others offer the following amendment. Amend the Senate Education and Youth Committee substitute to House Bill 283 by inserting after year on line 271 the following. Funds appropriated pursuant to this code section shall be used in accordance with recommendations of the school level governing body established by the charter or to advance student achievement goals and school level governance training objectives pursuant to the charter and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 37th, Distinguished Education Chairman, to present the bill along with the amendment.
Thank you, Mr. President. Members of the Senate, I bring you House Bill 283. Deals with Title 20. It's our annual education bill. It's cleaning up of some of the areas in Title 20. It repeals some very old and obsolete sections, an example of which would be including superintendents in courthouses and mandating that they would have an office in the courthouse. It renders obsolete the top-down restrictive definitions of how middle schools must run as far as limiting criteria they put on it as far as which grades can be housed together and which can't. It adjusts the QBE funding formula weight as a direct benefit of health benefits being moved to a different line under the QBE formula. It establishes a grant program for increasing access to high-speed bandwidth in schools. The grant allows the state to purchase capital technology equipment for local schools with bond dollars, and also increases overall bandwidth in the state today. Has QBE changes from the commission around administration, psychologists, and counselors. Allows more flexible use of money for supplemental education and instruction. Renames vocation to career technical and agricultural education. Removes obsolete no child left behind language. Renames the charter commission schools to state charter schools. Adds accountability language for charter systems. Implements budget savings by capping a charter system grant at $4.5 million instead of $100 per student. Sets up nonprofit foundations for the Office of Student Achievement to accept private charitable donations for innovation, and this follows after similar. This would follow after similar race to the top programs which rely on these type funds expire. Renames guidance counselors to school counselors, fixing as unintended consequences in IE square government language, where the system under contract would be sanctioned early if they did not meet all goals in year 3 of 5. Clarifies pre-K students to have preferences to enroll in affiliated charters, and clarifies Board of Education responsibility on pre-clearance of redistricting. Mr. President, if there are no questions, I'll yield the will.
Chair recognizes Senator from 22nd for a question.
Thank you, Mr. President. Senator, do you yield?
Absolutely.
Senator, in Section 2 of the bill, lines 27 through 43, help me understand what it is you're trying to accomplish here. As I read it, under what premise would a member of a local school board be subject to a misdemeanor charge if they did not comply with the Voting Rights Act?
Would you repeat the question, sir?
I will be happy to. Under what circumstances, in paragraph A, would a member of a local school board be subject to a misdemeanor charge as it relates to lines 27?
If they fail to follow the provisions under this code section, they would be. Yes, sir.
And is this in reference to redistricting, or?
This has to do with following a redistricting that has to do with that local district and redistricting plans that have been approved by the General Assembly.
Does the Senator further yield?
Yes, sir.
Senator, are you suggesting with this language that if a member of a local school board fails to comply with submitting or participating in a redistricting action that this legislature took effect on, that they would be guilty of a misdemeanor?
I believe that's correct. I believe that's what it says. Yes, sir.
Okay. Thank you.
Chair recognizes Senator from 33rd for a question.
Senator Yield.
Absolutely, brother.
Senator, let me ask you, there are two things that worry me a little bit. Is it not true that you stated this was our annual education update?
Generally, we do have an omnibus bill that deals with everything that can be thrown on it. So, yes, it is an update of sorts.
But you further yield, Senator?
Absolutely.
Is it further not true, though, that it's a little bit more than that, since we're dealing with consolidation of schools and the change in the weights formula of the QBE program overall?
Strange how legislation changes when it gets on the table, but yes, sir, it has changed somewhat.
Thank you. Honest answer.
No further, I'm sorry, there is, no, waves it off. No further questions, Senator. Senator from the 33rd, do you wish to speak? You are recognized to do so, and then the senator from the 12th.
Mr. President, ladies and gentlemen of the Senate, we all serve on anywhere from 4 to 6 committees, I guess, whether you're an ex officio member or if you have something that they've appointed you to, but at least 4 committees in this Senate. It's impossible for us to read and know everything in every bill before it comes to the floor. I'm going to admit that. But I probably read the first readers and the bills on the calendar as much as anybody in the Senate. And I will tell you that if you were to tell me that you understood what the change in the weights and the formulas do under QBE under this bill, I would tell you, other than about 3 of you, you do not. Now, we are addressing more than just one issue here. This is not, in my opinion, with deference to my good friend, lifelong friend as a matter of fact, but this is not an annual update bill. This is a substantive change in education and consolidations. And if you don't know what it is, you better look at it. Because on page 5, 6, 7, and 8, you see we strike some weights. We go down in some weights as far as the alternative education program. We go up in some weights for remedial education. I don't know if you understand every one of those weights and weight changes according to FTE, full-time equivalent per student. But I think we need to know it a little better before you cast your vote on it. I'm telling you that this is a complex issue. I've been through it. I had to read a 270-page bill one time, and I hated every page of it. But I knew a lot about education when I got through it. I almost felt educated. But I'm telling you, this is more than an annual update. It's doing some things that are pretty far-reaching, and I'm not trying to hurt my friend, the chairman of education, or the administration, or anybody else that's involved in this, but I would tell you that I would hope that the education community is on board with this, and I would have liked to have gotten some letters from those folks, whether it be the Superintendents Association, or whether it be the teachers, or whether it be the PTSAs. I'm betting a lot of them don't know about it. So I just want to express some caution. It does more than an annual update. It changes the QBE formula, and it adds some new consolidations of schools that is going to be controversial. It may be the right thing to do, but it's going to be controversial.
Chair recognizes Senator from the 12th.
Mr. President, ladies and gentlemen of the Senate, House Bill 283 is an extension of who I am as a lifelong educator. And as part of this detailed and extensive educational mission, I logged in quite a few hours on the Education Study Commission, trying to work through the process. Therefore, I am committed to its passage, but there are some concerns, like the senator from the 33rd, that I do have. Representative Chokas, without any discussion with the senator from the 12th, added Section 2 to HB 283 that has implications that are either for or against. I don't know, because I didn't get an opportunity to have that discussion with him or anyone else from the county. And I wish that I could afford you or give you an opportunity to have clarity on that issue, but I don't have any because I did not get an opportunity to discuss this with the representative from Sumter County. There have been no calls or faxes or emails or texts or visits from anyone saying that they needed this additional legislation. So as a state senator representing parts of Sumter County, my pledge to those individuals that I represent was to always acquiesce to them, local control, and to work for the people of Americas with that premise always at the forefront. Now, the language in the bill appears to be fair, but I remain unsure because I did not get an opportunity to have a fair and open discussion with the representative. He approached me the morning of this bill going into committee, and it was rushed through. And I hope in the future that we can at least give local control a chance before we decide it is ours to do in the legislature, state legislature. Having said that, Mr. President, I'll yield the well. You have a question? Yes.
You do have questions. Chair recognizes Senator from 26 for a question. Waves it off. Chair recognizes Senator from 33rd for a question.
Yes, sir.
Thank you, Senator. Do you yield?
Yes, sir.
Senator, we indemnify teachers. Do we not represent public school teachers if an action is brought against them?
Yes, sir.
But we're here because of one or two examples in the state. We're saying that a local board shall not expend any funds to defend a board member.
Yes, that's what this bill says.
And how many qualified people do you think are going to put their personal liability out there to run for the school boards?
I have no idea, sir. Not many.
Well, let me ask you, would you yield for one further question?
Yes, sir.
And I'm really being sincere in asking this because the thing that I mentioned about the weights changing substantially, have you gone over those and understand what they do, what they cut, and what they increase? What the net result of it is what I'm asking you, if you agree with it or don't.
I do, because there was extensive work done on all of this. I'm just carving out this exception because it was added in at a later date.
But you're saying that an
Yes.
education commission put this together and studied it, and that you agree with the weight
Yes,
formulas that come forward?
Yes, sir.
That makes me feel a lot better. Thank you very much.
Appreciate you.
You do have some additional questions if you'll yield. More questions? Senator
more.
42nd waves off. Senator from the 37th is recognized for a question.
Senator, do you yield?
Yes, sir, I do.
Is it not true that on a close reading of this bill, the preclusion of using public funds for the defense of a school board member's actions only apply to the provisions of this section and is not a general exclusion. A school board member is entitled to legal representation for any actions that they
Yes,
have.
sir. If you heard what I said the information is probably okay. There shouldn't be any real heartburn that comes with this legislation. I'm concerned that I was unable to have any kind of conversation with the gentleman from Sumter County that represented. I represent Sumter County too, and would like to have had an opportunity to sit down and discuss this information prior to the 2 hours before going into committee. That's my concern.
Thank you, Senator.
Yes, sir. Thank you.
Senator from the 41st, you wishing to speak? Waves it off. Oh, I'm sorry, we have a second amendment. Secretary will read.
Amendment 2, Senator Davis of the 22nd offers the following amendment to the substitute to House Bill 283. By striking lines 24 through 42, striking lines 866, 867, and 868. Through with the order, Mr. President.
Chair recognizes Senator from 22nd speak to his amendment. It's a late arriving. Can we put it up on the board? We'll get it up on the board as soon as we can.
Thank you, Mr. President. Members of the Senate, I rise in support of what I believe will be amendment number 2. In section 2 of this measure that's before us today, I'm simply requesting that we strike this. I'm not quite sure what the origin of the language in lines 24 through 43 are, but I would cause you to pause for a moment. I'm not quite sure how, at the end of the day, it is the members of the legislature who are responsible for redistricting measures. I'm aware of several instances across the state of Georgia where members of this body, this legislature, whether it be in the House or the Senate, for years have gone on without even redistricting in their districts, have gone on and not even implemented it. And to suggest that a school board member should be guilty of a misdemeanor and summarily have that on their records, I think is wrong. At the end of the day, we're the ones responsible from a redistricting perspective to not only draft all redistricting measures, but then to make sure that they are in fact implemented. And so what I would ask for your favorable consideration in striking that language. It doesn't add anything of significance to this measure. Quite frankly, it doesn't even need to be in this measure. And I would ask for your favorable consideration in striking it. At the end of the day, doesn't add any value to it. I'll be happy to.
Chair recognizes Senator from the 26th for a question.
But Senator Yield,
I will.
Isn't it true by state law that reapportion counties and boards of education?
That is true.
And that the only somebody that we don't have to reapportion are cities under home rule?
That is true.
And is it not also true that on the Section 2, this is new law?
I believe the gentleman is correct. This is, in fact, new law, and I believe has no merit in this bill.
Would the gentleman, Senator further yield?
I will.
Well, how does a local board member refuse to do a submission when it is the law that the General Assembly draws the lines and have them submitted to the Justice Department?
Well, again, I think the senator is correct, as he so states. What I would also offer is the fact that it is the General Assembly's responsibility for all redistricting measures, and as such, if anybody should be guilty of a misdemeanor of not complying, then we should be guilty of that. That's why I ask for your favorable consideration.
Mr. President, if there are no further questions, I yield the wheel.
No questions, Senator. Okay, the question is on amendment.
What's the deal? Straight through line 43 here.
It was supposed to have been 43, Mr. President. Unanimous consent.
So instruct us to do it. Okay.
Chair recognizes Senator from the 22nd.
Thank you, Mr. President. Mr. President, I ask for unanimous consent to amend.
Yes.
Amendment
number 2.
Amendment number 2.
By striking lines.
By striking lines.
24 through 23 instead of 22.
By striking lines 24 through 43.
43.
Instead of 24 through 42.
Instead of 42, 43 was what his amendment meant to.
Yes, sir.
To be. Is there objection with his amendment? Without, no. Without objection, the amendment will read 24 through 43. Now, we're taking up amendment number 1, authored by the senator from the 37th. Is there objection? Without objection, amendment 1 has been adopted. Now the question is on amendment number 2. Is there objection? There is objection by the chair. All those in favor of amendment 2 moves the yeas and nays will vote aye. Those opposed, no. Secretary will unlock the machine. You are voting on amendment number 2, authored by the senator from the 22nd, and with the chairman's opposition. Senator from the 26th is recognized. What purpose do you rise?
A parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true that the members of the General Assembly failed to reapportion Hancock County for over 20 years?
Sure, the senator knows from which he speaks.
Mr. President, another parliamentary inquiry.
State your inquiry.
Shouldn't the members of the General Assembly who failed to do that be held liable for a misdemeanor?
Sure, the senator has great passion for which he speaks. On amendment number 2, the yeas are 20 and the nays are 25, and amendment 2 has lost. Now, the question is on the adoption of the committee substitute as amended. Is there objection? Without objection, committee substitute as amended is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agree in a Porter committee which fail pass the bill? Chair is none. Porter committee is agreed to. Shall the main question be now put? Are there any objections? The chair is none. The main question is ordered. Shall this bill now pass? The question is on. Pass to the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the pass of the bill, the yeas are 33 and the nays are 14, and this bill, AMC Rex constitutional majority, is therefore adopted. Secretary will read House Bill 298.
House Bill 298 by Representative Dickey of the 140th and others. A bill to be entitled an Act to amend Chapter 8 of Title 2 of the OCGA relating to agricultural commodities promotion so as to create the Agricultural Commodity Commission for Georgia-grown products and for other purposes. The Committee of the Senate on Agriculture and Consumer Affairs recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes distinguished Agriculture Chairman, the Senator from the 50th.
Thank you, Mr. President, members of the Senate. House Bill 298 would create an Agriculture Commodity Commission for Georgia-grown products. Georgia-grown products would be defined as any agricultural products grown commercially in Georgia. This would give growers the opportunity to buy a licensing agreement to have the Georgia-grown logo displayed on their products when they're ready to market their products. Mr. President, if there are no questions, I'll yield the well.
There are no questions. Does any other senator wish to speak for or against the bill? Is there objection? Grant report of committee which favor pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Question on the pass the bill. All those in favor of the bill vote aye. Those opposed no. Secretary unlock the machine. On the passage of the bill, the yeas are 49, the nays are 0. This bill, having received requisite constitutional majority, is therefore passed. Secretary will read House Bill 304.
House Bill 304 by Representative McCall of the 33rd and others. A bill to be entitled an Act to amend Code Section 48-5-48.2 of the OCGA relating to Freeport exemption so as to clarify the applicability of an exemption to fertilizer production processes and for other purposes. The Committee of the Senate on Finance recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes Senator from the 50th. Present the bill.
Thank you, Mr. President and members of the Senate. House Bill 304 clarifies that the custom blending of bulk, nitrogen, phosphorus, and potash does indeed constitute a substantial modification of these raw materials, thus meeting the standard for the Freeport exemption. These raw materials have been considered eligible for the Freeport exemption ad valorem taxes for a long time. There's been some question recently, and we wanted to clarify this. As members of this body are probably aware, fertilizers come in a variety of blends, custom tailored to the crop, the soil test, and other factors. So there are different kinds of fertilizer, but all this bill is saying is that the raw material used to make custom blended fertilizer will be eligible for the Freeport tax exemption. Mr. President, if there are no questions, I'll yield the well.
Do have a question. Chair recognizes Senator from the 33rd.
You yield, Mr. Chairman?
I'll yield.
as you stated, now this bill has nothing to do with anything other than helping local farmers that qualify for the Freeport tax exemption. It has nothing to do with the way we use these products or what they're intended for, the security thereof, right?
That's correct.
Okay, thank you very much. Appreciate it.
Okay.
No questions, Senator.
Thank you.
Does any other senator wish to speak for or against the bill? Is there objection? Grant the Porter Committee which favor pass the bill. Chairs none. Porter Committee has agreed to. Shall the main question be now put? Are there any objections? Chairs none. The main question is ordered. Shall this bill now pass? Questions on the pass the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the pass of the bill, the yeas are 56, the nays are 0, and this bill, having received requisite constitutional majority, is therefore passed. Senate's going to stand at ease until 4:30. 4:30, 15-minute break.